A good day I bid to you, Dr. Ani. My name is Ho Yu Wei and my matrix number is 255818. Today I will be presenting on the Dworkin's One Right Answer thesis. As prelude, I think it is essential to first explain Hart's legal positivism before we delve into the One Right Answer thesis developed by Ronald Dworkin. In this viewpoint, Hart standpoints that there is open texture in law and judges thus have strong discretion in jurisdiction. Disagree to this viewpoint, Dworkin made a theoretical reply and developed the One Right Answer thesis as to rebut what is in the Hart's legal positivism theory. And this One Right Answer thesis says to the contrary, saying that there can be no open structure in law, and even if in hard cases there will be only one right answer, thus judges will not have strong discretion to depart from the established legal principle. For this discussion, I will be deliberating on three contributions that is made under One Right Answer thesis. We can see that this One Right Answer thesis had limited judges to exercise their discretion because Ronald Dworkin thinks that there can only be one right answer and the judges are bound by it, so they only have limited discretion in departing from this one right answer. Firstly, we can see the contribution being made is that this One Right Answer thesis preserves the sanctity of separation of power. You can see separation of power is very important because it ensures the balance between three bodies in Malaysia. Malaysia is a country that respects separation of power, even though we do not practice absolute separation of power. It is apparent that the executive and legislature in our country to a certain extent will overlap. However, the judiciary remain impartial and not encroached by any of these two bodies. It is important for judiciary to be free from fear and favor, and to maintain this position, the judiciary must do the same. They cannot exercise their discretion relentlessly and to make new law contrary to the legislature's intention, because this will be considered as a blatant disregard of the separation of power. It offends the democratic idea that a community should be governed by elected officials answerable to the electorates, which is us, Malaysian. We cast our vote to choose parliament member to create law that can have positive effects and that preserve our rights and privilege. The judges are not elected, therefore they cannot and must not substitute their own will as against the legislature. And to quote Lord Simon's word, it is a naked usurpation of legislative function if the judiciary does not respect the intention of legislature. For the second contribution made by Dworkin's One Right Answer thesis is that it upholds procedural fairness. We can see Dworkin's second objection was to oppose against judicial originality. Judicial originality is a practice of legal realism, legal positivism that allow the judge to interpret section or provision on their own fancy. It allows judges to exercise their creativity, their discretion in giving new meaning to the statute. So if a judge makes a new law and applies it retrospectively in the case before him, then the losing party will be punished not because he has violated some duty he had, but rather a new duty created after the event. You can see the rules was stating A, but after the interpretation and discretion of the judge, it had become something else. The judge has distorted the meaning of the rules or the statute into B. We can see this judge had added some new elements in defining the law before him and create a new set of law. And the repercussion for this is that if this new set of law was to apply retrospectively to the accused, it would violate procedural fairness. For the third and final contribution is that Dawkins thinks that legal principle plays a vital role in the absence of legal rule. More precisely, Dawkins thinks Hart's and his legal positivism had limited the concept of law within legal rule. Therefore, Dawkins had tried to extend the concept to include legal principles and policy. Under Hart's legal positivism, it is clear that if the case is sufficiently plain, the judges can just subsume the concrete facts under a general rule and draw an analogy. But if the case is very hard and there is no example or precedence for the judges to draw analogy, Hart thinks that they can use discretion and to exercise their creativity. I would like to point out a famous example is that if there would be a rule saying no vehicles in the park, a motor car is surely within the core of the concept vehicle. But how about bicycles, airplanes, and roller skates? In easy cases, judges could just assume that these all fall within vehicle according to the legal rules. But in hard cases, there is no legal rules for them to follow, and thus they have to make a decision based on their own decision. And for these, legal principles come into the picture. Legal principles can function as justification of legal rules. Dawkins' example in Riggs vs. Palmer, in which judges make a decision that Palmer could not succeed the legacy of the victim because he has murdered him according to the principle that no man may profit from his own wrong. Dawkins points out that the judgment in this case in fact established a new rule because before it there is no such rule. But it doesn't mean that judges are law-making for the reasons that this principle is part of the law and justify the rule. As for conclusion, I would like to summarize that Dawkins had portrayed three contributions under his theory, which is firstly, this one right answer thesis preserves the separation of power, and secondly, it upholds procedural fairness, and for the last but not least, Dawkins' right answer theory or thesis emphasizes on legal principles when there is an absence of legal rule, as I have discussed in the discussion previously. Thank you.